Well, Mr. Rod, I'm very pleased to meet with you finally. Your son is a friend of my son, Brian.
So I understand.
Yes.
It's good to meet you too, Mr. Hull. I've heard a lot about you. And I apologize about yesterday. I completely forgot about that appointment.
Oh, well, that's all right.
Please let me know about future appointments. He gets a little forgetful, you know.
All right, I'll notify Ted now. What's your... Oh, my secretary probably. Well, she'll get your number later.
Sure.
That's okay. Now, how can I help you, Mr. Rod?
Well, I want to bring my will up to date.
I see.
It's been some time since I've done it, and circumstances have changed. Assets have grown a bit, and my ideas have changed a bit.
Well, if you're going to talk to me about a will, I assume Ted's going to be a beneficiary.
That's right. Yeah.
Well, I think that Ted should leave the room and go down to the waiting room until you and I are through discussing.
Oh, no, I don't think so. He's going to have a little trouble with details. He knows what he wants. He's told me about it. You want me here, don't you, Dad?
Well, very definitely. You see, Mr. Hull, Ted runs the business.
I see.
And he looks after all of the details, and actually he took the initiative in telling me I should come down here and update the will.
That's right. I know the apartment buildings really well.
Well, all right. You're satisfied that Ted should be here?
Yes, I'd like Ted to be here.
All right. Do you have your old will?
Yes, I have it right here. Old is the word. It's drawn in 1954. That was a few years ago by the late Dan McGrew, you may remember.
Oh, yes, I remember Dan well. Yes, quite a character, Dan.
Fine gentleman. Good lawyer. Good lawyer. But things have changed.
Yeah, it's a pretty simple will, isn't it?
Yes, it is.
You left everything to your wife, and if she predeceased you, then your children took equal.
That's right. That's right.
I see. Now, tell me, what do you have in mind here?
Well, what I'd like to do is leave Ted the
apartment buildings. I know them well.
But we're going to leave Martha, my wife, Martha Jane, a life income, and I want her to be able to, if she needs to get at the capital.
Yeah, well, we call that a power to encroach.
Whatever you lawyers call it.
And so that she'd get the interest from your
That's
income
right.
from your
That's
estate,
right.
and then if it's not enough, then she's entitled to ask for more from capital.
That's right. She doesn't know very much about business. And
she doesn't want any part of the business aspects.
Doesn't get along with Ted all that well either. And I want her to receive a monthly check. You know, she'll feel very secure if she gets that check coming in every month, and if there's anything else that has to be looked after, I know Ted will look after. And then we'll give the apartment building to Ted.
Well, have you got any other children?
Oh, yes, there's a daughter, Blanche. She's living in Russia. She married one of those civil servant types, and we see them every 3 or 4 years. He doesn't know anything about business. She doesn't know anything about business. And but I want her to get whatever is left, the stocks and bonds and things like that.
Well, now, tell me, what assets do you have?
Well, it's just mainly the apartment building, which is worth about,
it's about $400,000. We've gone through all the
That's about
figures.
right, about $400,000.
What's the address of that apartment?
That's 170 Broadview.
That's right, that's right.
And that's just over opposite the school there.
That's right, that's right. It's about 48 suites.
And you say that's worth about $400,000?
That's right.
And that's a pretty accurate estimate of what it's worth today?
Oh, yeah. We've gone through all the books. That's right.
So.
And what else do you own?
Some stocks and bonds and term deposits, little money in the bank, and well, I figure that would be worth about...
It's about the same, about an equal split. About $400,000.
You say that your stocks and bonds and your cash, the liquid part of your estate,
that's
is
right,
about
Mr. Hull.
$400,000.
Yeah. She'll get all that part.
I see. So you want Ted to have the apartment and her to have the stocks and bonds and what's left.
That's right.
I see. So now I can tell you, Mr. Rod, if those aren't about the same value, when you die, there's going to be trouble.
Look, we've gone through all the particulars. We've sat down for hours through this. It's his property, Mr. Hall. I don't think you need to go any further. He knows what he wants to do with it. He just wants you
Well,
to
it's his
draw the
will as
will.
well, too.
I've got my reasons, Mr. Hull, and it can take time and...
Well, all right, I understand then. I don't need to know those reasons in these circumstances. I think I understand what you want. Now, just a moment, I'll get my secretary in, and she'll take down the details. Teresa, would you bring your book in, please? I'd like to talk to you about Mr. Rod's will. Thank you. Teresa, this is Mr. Rodney's son, Ted.
Nice to meet you.
To meet you.
Now, I wonder, Mr. Rod, can you tell me your full name, please?
John Henry.
That's R-O-D-D, isn't it?
Please, that's
Yes.
right.
And what's your name, Ted?
It's actually Theodore Albert.
And that's Rod.
That's right,
R-O-D-D.
yes.
And what's your daughter's name, Mr. Rod?
It's Blanche Louise, and it's Petrov is the surname.
Could you spell that, please?
Petrov.
Thank you.
They're off in Leningrad now. And my mother's name is Martha Jane.
All right, now, Teresa.
Let me give you my phone number, too. It's a lot easier dealing through me than Dad here, but 634-5789. Make sure he doesn't forget any appointments or anything.
All right, Teresa, this is Mr. Rod's old will. And you remember last week we had Mr. Comatose come in, and he did just about the same thing.
Right.
Except we got to talk again about the apartment building and the residue of those assets, because that's not exactly the same. But what Mr. Rod wants to do is just as Mr. Comatose does. Remember, there was an absolute gift to the wife in Mr. Comatose's case, and then if she predeceased him, then to the children. Well, now, this, you change it to put the income with the power to encroach to the wife. You know that funny clause that says that in the event that she predeceases me, well, you got to take those words out and put upon the death of the survivor of me and my wife. Have you got that?
Yeah.
All right. Now, as I say, Teresa, I'm going to have to talk to you again about that apartment. Now, you'll remind me to talk about that later.
Okay.
All right. Now, Teresa, can you think of anything else that I should be asking Mr. Rudd?
I can't think of anything right now.
Okay, that's fine.
Okay.
You just get along. Bye.
Bye-bye.
Now, you don't need to worry, Mr. Rod. This isn't a very complicated thing. We do this hundreds of times, and you don't need to worry. It's what I call the midlife crisis special. And I've done it 100 times.
Well, I thought it would be a lot more complicated, quite frankly.
Well, it's not that bad.
Mr. Hall, there were just a couple of things I wanted to talk to you about in the Rod will.
Oh, yes.
I don't believe you mentioned who the executor would be.
But didn't we ask him?
I don't think so. It's
You
not-
didn't make any note of it, eh?
No, I didn't, no.
Oh, I don't seem to have any notes of that meeting.
Oh.
Well, let's see now. I guess we can't have the daughter as an executor.
No.
She's over in Russia. He
Yeah.
wouldn't want that. Now, the son's got to be an executor. I wonder what about the mother? The son doesn't get along with the mother, I
I
think
think
he
that's
said.
what he mentioned, yeah.
Yeah. Well, let's just make the son alone, and then
Okay.
we won't have any hassle.
Okay, and the other aspect you wanted me to mention was about the apartment building.
Oh, yeah. Now, this is a little different than, you know, that comatose where what you got to do is, on the wife's death, you leave the apartment building on such and such a street to my son, Ted. If you got the address, just if you put the address in it.
I think it was 170 Broadway.
Yeah, well, you better, it's the one across the street from the school. You better just at the lunch hour check and make sure that that's the
Okay.
number.
Okay.
And, but it's important that we just make sure that it's the proper address.
Okay.
Now, as for now, then the residue, the rest of the estate. Remember he talked about, or I mentioned that he wanted his liquid assets, the stocks and bonds and banks.
Mhm.
Well, now, don't bother to spell all that stuff out. Just provide the residue is to go to the daughter on the wife's death.
Okay.
And they tell us that that's the same, they're each the same value, so that'll
Okay.
solve that problem. Is that all right?
That's fine.
Okay, thanks, Teresa.
That's all I had. Thank you.
Okay. Hello? Yes, Teresa. Oh, God, that's right. Rod's coming in to sign his will, isn't he? Jesus. I'm having a hell of a time with this real estate deal. You know, they forgot to check municipal bylaws. You've got to get after those people, you know. And your statement of adjustments is wrong, and I'll be able to correct it, I think, in the time. But, look, geez, I haven't seen the will either. Well, it's in my file here, and I haven't had a chance to look at it. You remember you remember now that about the apartment building? You got the right address? Okay, you checked that. And did you check it with Rod? Oh, you went by at lunch hour. Okay, that's all right. We know the apartment building. And then what about that residue clause? You sure you didn't refer to stocks and bonds, and you just gave the daughter the rest and residue of the estate? The words rest and residue are in, eh? To the daughter, after the wife's death. Okay, now, I haven't had a chance to read it. You proofread it, have you? You're satisfied with it? And it's just like the comatose will, eh? All right, now look, I just want to get this statement of adjustment straightened away, and I'll call you when you can tell them to come in when I give you a call, okay? Thanks, Teresa. Oh, how are you, Mr. Rod? Glad to see you again.
Good to see you, Mr.
I've got your will prepared here.
Very good.
I suppose you don't mind if Ted, I've got an extra copy here. So it's all right,
By all
Ted,
means.
look at it?
He wants me here to go through it, sure.
All right. Well, let's just go through that will. I don't think we need to read every word, you know. All this last will and testament stuff. We call that boilerplate. But you'll see that there's a life interest, you know. Upon my death,
I see.
the life interest, the income to my wife for her lifetime.
That's right.
And then you see it goes on to say that if the income isn't sufficient, upon the executor's discretion, then she can have some more money out of capital.
That's what I want.
And then when she dies, or if she dies before you, and then when you die, you'll see that Ted gets the apartment building.
There's the apartment. Right. Yeah, that's right.
And then your daughter gets the residue. Now remember, I think I explained it the last time that I use the word residue because it's really all your stocks and bonds, and that's all you've got.
All the rest, that's the idea.
And you're still satisfied that they're about equal, the apartment and the stocks and bonds?
No question.
Oh, yeah, we've been through all that.
No
Well,
question.
all right then. Let's get this signed up here.
That's fine. Is that the spot?
Yeah, right where it says your name there. Just sign your name. Just your ordinary signature. All right. Now then, you can't witness this, Ted. You're a
All right.
beneficiary. I'll witness it. Just a sec. I'll get Teresa in. Teresa, will you come in and witness Mr. Rod's will? Yeah, thanks.
Hi.
How are you, Teresa? Nice to see you again.
Right.
Here's his will, and you'll see where he signed and I signed, and if you'll just witness that will, that'll be just great. Well, thanks very much, Teresa. That'll be just
Okay.
fine.
That's fine.
We'll
Nice to have met
we'll
you.
make a true copy. I'll get a true copy. Now, what I'm going to do here, Mr. Rod, is I usually keep the originals in my vault, and then when anything happens, then everybody knows where the will is, and I can get right to work on things.
Whatever your practice is.
And,
You can leave me a copy.
well, I'll send... You want me to send Ted a copy?
Send it to Ted.
Well, I think, Ted, it might be an idea if you just... I'll send you 3 copies. And
Fine.
then you can send them one off to your sister and one off to your mother.
Fine, I'll do
You
that.
discuss it with your mother. And
Oh, yeah.
fine.
Oh, sure.
And if you do that, then everything should be fine. Is that all right with you if you
That'll be
discuss
just
it with
fine.
everybody?
Fine.
All right.
Quite content.
Okay, fine. Well, it's been very nice meeting you, Mr. Rod,
Nice
and I
meeting
hope I
you,
don't
Mr. Holt.
have to do anything on this matter for many, many years.
I hope you don't either.
Thank you.
Thank you.
Hello? Who's he, Teresa? Oh, he's a lawyer. All right. Put him on. Hello? Yes, this is Rodney. How? Well, I don't know you, but what are you calling about? You're the solicitor for somebody Petrov. Oh, what? Oh, yes, yes, yes. That's Mr. Rod's daughter. Ah, yeah. Oh, poor fellow died, eh? Was it sudden? Oh, I see. I suppose the daughter's over here for the funeral. I see. Well, that's too bad. Oh, she's seen the will, has she? Well, she saw it some time ago because the brother was going to give her a copy. He didn't, eh? And the mother's mad as hell, too. Why? Because she's just the executor. She's not an executor. Well, that's what he wanted. Sure. I can't help that. What do you mean, the daughter's upset about what? Well, the son got the apartment building, I remember that, and she got the rest. And they're both worth about the same. Oh, the apartment building's worth how much? $1 million. Whew. They didn't tell me that. I think he told me it was worth about $400,000 and that the stocks and bonds were about $400,000, and they each share the estate on that basis. Son got the apartment, the daughter got the rest. The daughter, you see, has been over in Russia. Sure, she doesn't know anything about the business. She said unhappy. Well, I can't help that. That's their instructions. They gave me the... no, I mean, Mr. Rod gave me the instructions. He told me how much it was worth. Well, I can't help that. I'm sorry. That's what they told me to do. Oh, yeah. The capital gains tax, yeah. Yeah, I guess that'll come out of the residue. Hey, how much is it? Ooh. Figure that much, yeah? $135,000. Well, I guess she just takes that much less. That's what the will says, doesn't it? Taxes to be paid out of the residue? Income tax? Yeah. Well, that's the way he wanted it, you know. Man can draw a will the way he wants to. Well, what do you mean I'll be hearing from you again? Look, young fellow, I've drawn hundreds of wills like this. Now, don't you get impudent. What do you mean, are they all as bad as this? Well, look, you just do what you have to do. I take my instructions from my clients, and I let my clients do with their estates whatever they want. All right. Goodbye.
Ladies and gentlemen, I'm Ralph Skane. On my left is Rodney Hull, and on his immediate left is Morris Cullity. Both of them are practicing lawyers who practice extensively in the wills and trust field. Both of them, I think, very well known to many members of the legal profession. Mr. Hull as a counsel and frequent participant in legal education programs in this area, and Mr. Cullity as a former colleague of mine in the field of academia, and also well known for his participation in Law Society and Canadian Bar Association legal education activities. Rodney, now that you've changed hats and are no longer playing the starring role as the bumbling lawyer in this particular case, as you look at yourself conducting that first interview, what struck you most from the point of view now of a lawyer who spends a great deal of his time in court attempting to repair the errors that have taken place in the preparation of wills?
Well, there were two glaring errors in that particular first scene, and that was the permitting the son to remain in the room, the son being a principal beneficiary, and permitting the son to participate in the interview to the extent he did. And of course, the other glaring error was the shallowness and the ineffectiveness of the interview of the client with respect to assets and other matters that simply weren't touched upon, and which we saw throughout the film caused a lot of problems.
Well, taking it to the first one, the permitting of the son to remain in the room, from the point of view both of the ultimate validity of the will and then from the professional reputation and potential liability of the solicitor, what are the problems that arise from what you have identified as a primary error?
I think that was a big mistake, Ralph. The fact that the son was in the room in those circumstances made it quite impossible for the lawyer to conduct a proper interview. He was not able to determine, he couldn't have determined whether the instructions were really those of the testator and not just the wishes of the sons. He was not able to determine whether the client's memory was so bad that it interfered with his testamentary capacity, and certainly he was not in a position to judge whether the client was acting under the undue influence of his son, or perhaps even under deception with respect in particular to the value of the apartment building. And when you look at all those facts, as of course everyone would do at the end of the day with hindsight, you see that the son answered all the questions. The son was the one person who should have known what the value of the building was. The son, of course, was a substantial beneficiary. The son did not deliver copies of the will to his mother and to his sister as he promised. All of those things, with hindsight, add up, I think, to fairly suspicious circumstances.
And if we do get suspicious circumstances, that finding, what follows down the line as you go into probate court? Rodney?
Well, then, of course, if there are suspicious circumstances, which are as suspicious as here, then I'm quite confident that the judge would put the onus on the person to justify and explain away those suspicious
circumstances. Which person do you mean?
The solicitor, particularly, to explain away those suspicious circumstances, and the son would be put to have the onus on him to explain away the facts and the circumstances.
In other words, the person's attempting to uphold the will.
The person's attempting to
improve the will.
uphold the will would have that onus, if it ever shifted, put back on their shoulders.
Of course, our concern, Ralph, is largely with the position of the solicitor.
Yes.
And the solicitor may not be particularly concerned about whether the will is propounded, but he is going to be concerned about his own reputation. He is definitely going to be called as a witness. He hasn't got notes. It's clear from other evidence that will obviously be given that the father had a bad memory. I think that solicitor is in a very, very dangerous position.
At the very least, he can expect, on the basis of the cases, for the judges to take a strip off him in public.
I would have thought, just on the basis of not keeping notes alone, he is in a fairly precarious position.
I'd have to say that. I think he would be perhaps facing a suit at the end of the scene, at the suit of the person who suffered any damages as a result of this lack of professional attention to what he should have been doing.
You'd love to be cross-examining him, wouldn't you, Rodney?
I would very much like to cross-examine that lawyer, yes.
Yes.
But it's not just the capacity and the undue influence. It's also the fact that he wasn't able, or he didn't persevere, and ask a number of important questions.
For example?
I don't recall him asking whether the son was married and had children. I don't recall him asking whether the daughter had children. I don't recall him asking what would happen if either the son or the daughter predeceased the mother. Was the apartment building to go to the daughter, for example, or was it to go to the children of the son? He certainly didn't ask, I don't think he asked who the executor was going to be, and he did not obviously turn his attention to the quite serious tax consequences of the provisions of the will as far as the daughter's concerned.
Now, with respect to that particular interview, the assets posed a difficult problem for a lawyer in drawing a will, just the state of the testator's assets as he described them, even in that cursory fashion, to the lawyer. Morris, you adverted to one of the problems, the tax problem down the line. One of the things that struck me, for example, was that there was no real indication of what the flow of income from the existing investments to the wife was likely to be. He spoke he wanted her to get a monthly check, but we had no idea whether that check was going to be for $200 or for $2,000. Might depend upon how his assets were invested. Stocks and bonds is a pretty wide range.
Wouldn't want to count on the generosity of that son too much either.
No. When you gave the son a power to encroach, It was very interesting that to the extent the son did encroach, it was going to come out of the daughter's pocket, presumably, the way that will sounded.
Well, that really draws, I guess, us to the question of investment powers. Was there to be an obligation to retain the apartment building? These are obvious things Rodney knows as well as anybody, obvious things that should have been addressed, and the testator's views should have been asked, and obviously also, again, in the absence of the son.
Yes. Just take, for example, that apartment building. Now, there is a rather peculiar asset in commercial real property. One of the problems that I can think of coming up down the line is whether or not the son, in managing the property, will be able to withhold from what constitutes the widow's income an amount for depreciation.
Well, that certainly was never covered in the interview, I can say that. I remember that.
Do you find it usually covered in your experience as you
I would
review
think
these?
that that's a matter that doesn't come readily to the attention of a professional advisor, but it's certainly the kind of thing that I think a person who is experienced in this field would consider.
Mm-hmm.
And they're difficult questions. I mean, the question whether the executor in this case would be entitled to retain a reserve for depreciation is not an easy one to answer. But the second aspect, which is related, is whether the executor would be entitled to pass through an income tax deduction for depreciation to the widow. And we don't know much, as Rodney said, about, or as you said, about the income flow to the widow, but that deduction might be very important.
And I think it's very important, too, to remember that the solicitor was suffering a very severe problem with that son, because the son kept answering all his questions, you see, and wouldn't let him answer. The old man answered some of them and said, oh, we've made up our minds on this. And so that son in the interview was really just something that had to be removed from the interview if it were to be an effective will.
Yes. Would you have ordinarily insisted on much more detailed information as to the valuations in that estate?
This is a difficult question. Obviously, one should ask, have you had the apartment building, for example, appraised recently? Do you think it should be appraised? Why do you think it's worth only $400,000? I think at the end of the day, if the client persists, as many of them will, and says, look, I know what it's worth, I know approximately what it's worth, I'm not going to go to the expense of an appraisal, then you must accept it. But of course, you keep notes and you don't throw them over your shoulder as the client leaves the room.
All right. Now, if I can move on to the second of the areas that we were looking at in that interview. Rodney, it struck me that in your other guys, you were placing a lot of weight and reliance on the ability of your secretary or your paralegal staff in that situation. In your experience, is that a problem? That
Well, I think the depiction of giving those instructions to a secretary or a paralegal is something. It's a responsibility and a task that can't be delegated from the lawyer. You can't ask your secretary to draw a will, and even if you can, in some circumstances, allude to former wills that might be applicable to that particular will. You, under no circumstances, in a will that had the problems inherent in this will, in getting the property to the son, and all the implications of how that was to be done, simply not possible to delegate that to a secretary. And that's professional negligence in my view.
Actionable?
It won't be long before it is actionable. If it isn't actionable now, certainly there have been claims made and cases put forward, but I don't believe it's ever been directly dealt with by a court in this jurisdiction.
But Rodney, if we're dealing with a case where the lawyer not only didn't draft the will, but then he didn't read it, do you have any real doubt that a court would find some way of...
I have no doubt that the judge's footprints would be on that man's back for some time.
But that was the problem here, wasn't it? He didn't give good instructions to his secretary, but then when he got the draft back, he simply didn't read it.
He didn't read it. No, he's clearly negligent.
And there is the reference to the will of your good client, Mr. Comatose, That, as I understand it, was a will where there was an outright gift to the wife, and if she predeceased the testator, it was to go to the son, and the property was to be divided between the son and the daughter. There have been, as the three of us know, at least 3 cases in Toronto this year in which a draftsman changing that kind of will to a will that leaves a life interest to the surviving spouse neglected to change the opening words of the gift over, so that the children would get the property still only if the wife predeceased the testator and not on her death if she survived. And I thought, and it's a little difficult to tell because we didn't actually see the will that was drafted, but it seemed to me that there was a big risk that you were going to end up with the same kind of mistake.
I attempted in the film to get over that problem, but to expect your secretary to pick up the difference between an outright gift and a life interest is expecting too much, and you simply can't do it. If you're going to be a lawyer, you practice law, and that's practicing law.
Do you think that a lawyer should proofread every will himself?
I don't think it's necessary for a lawyer to proofread every will. I think he has to be satisfied and create a system in his office which will ensure accuracy and the proofreading process. Because after all, a lawyer is no better at proofreading a will than a secretary or a paralegal person trained to proofread. But the lawyer is responsible, and he has to be responsible if there's a mistake. I think a lawyer has to look at every will. I think he has to look at the dispositive clauses, particularly to make sure that they do what the solicitor or what the testator asked them to do, and to ensure that his intentions are clearly set out there. And if he doesn't need to proofread the investment clause because he can assume it's properly done, but he has to read it. He has to see that it is what the testator wants.
Now, if I can go down to the last stage where the client came in for the interview, it seemed to me that one of the great problems, of course, was that the client had to rely completely on that lawyer for the will saying what he thought it said. At that particular stage, how do you see the lawyer's duty? And
well, this was an opportunity, on the facts as we saw them, for the lawyer to ask the questions that he didn't ask the first time round, and if he got answers, like, for example, if the testator said, "I want my wife to be one of my executors," then it would have been an opportunity for the lawyer to fix up the will. That's the first point. Of course, none of these questions were asked. There was still no reference to tax consequences. But the most important point is that he gave the client no opportunity to actually read the will. And Rodney was talking about having a system in the office for proofreading. I think it's quite important to at least have a well-established practice that before the client comes in, you send a draft of the will out with a covering letter explaining what its terms are, so that at the end of the day, nobody can turn around and say he didn't know what was in it because you didn't give him an opportunity to find out what was in it. But in this case, at this stage, as I think at the second stage, it's quite clear to me that the lawyer was negligent. He simply did not read the will himself. The client didn't read the will. And if we move on to the final scene in this little drama, of course, the will was not validly executed because the testator neither signed the will nor acknowledged his signature in the presence of the 2 witnesses who then signed. And that one, I think we'll all agree, when you get to that mistake, that is clearly actionable even under the existing authorities.
I would agree with that.
Rodney, just to wrap it up, perhaps you could summarize for us what you saw as the errors of procedure that lawyer made which posed problems for him down the line.
Well, all right, let's start at the beginning. I think, as I mentioned, the permitting the principal beneficiary or one of the principal beneficiaries to remain in the room, the shallowness of the interview, not sufficient questions asked, not a sufficient cross-examination of the testator as to his ability to understand what he was doing or to remember what he was doing, and then the superficial way in which the instructions were given to the secretary, and the fact that the secretary simply is not qualified to do the work that she was delegated, and And to that extent, I think that would be a professional error. And then, of course, the fact that the solicitor didn't read the will, didn't draft it or didn't read it, didn't proofread it, although you've heard what I've said about proofreading. And then again, for the final indignity was the fatal mistake of having the secretary outside the room when he signed and then bring her in to provide an illegal will. Of course, the will was not valid, an invalid will. And I think those are the main points that we had. Have you got any?
I think the only point I'd add, Rodney, is the failure of the lawyer to consider and to refer to the client the possibility of serious tax consequences. But apart from that, I'd summarize the whole performance by saying it was a great dramatic achievement.
But wrapping all of that up together is the possible legal consequence of this. 15 years ago, I think we would have said that however damaging all of these miscues may have been to the lawyer's professional reputation, and if you're familiar with the law reports, judges have not hesitated to publicly tear large strips off lawyers for the type of errors that have been made here and have those results published in the law reports. But from a point of view of liability, some time ago, I think we would have said that perhaps apart from the cost to the estate of unnecessary litigation, since the lawyer's liability rested on contract with his testator, that the estate as such suffered no loss simply because the property went to A rather than B. At the present time, I think it's quite clear that we can no longer say that. The law is still being shaped, but it seems to be quite clear that the judges are now starting to approach this from a general tort view. We have had the misrepresentation approach started to be taken in British Columbia, where it happened the client was in the room, but certainly in England and in other cases we are now starting to see a straight negligence tort approach where clients who would have benefited where beneficiaries who would have benefited had the will been properly drawn and upheld and are disappointed by the lawyer's failure to carry out his professional duties have, I think, an increasing likelihood of being successful in a tort action. We still are in a very vague and preliminary state of the development of that law, but I think no lawyer can rest assured that he had the immunity that we would have thought he had 15 years ago.
I would agree with that. It's a serious problem, in fact.
Thank you very much, gentlemen.